Welcome back to the Constitutional Clarion. Along with its rather dubious bills on misinformation and campaign finance reforms, which I've dealt with in other videos, the Commonwealth Government has now introduced a controversial bill to exclude people under the age of 16 from social media. It's the Online Safety Amendment Social Media Minimum Age Bill 2024. Given the importance and complexity of this issue, you'd expect it to be properly scrutinised by a parliamentary committee. But you'd be wrong. It's going to be sent to the Environment and Communications Legislation Committee, but for such a quick inquiry that no one will actually have time to write informed submissions. The bill was introduced into Parliament yesterday my time, so on the 21st of November, and the closing date for submissions is, today, 26th of November. The committee says that due to the very short time frame of this inquiry, which is to report on Tuesday, 26th of November, it would appreciate submissions being limited to 1 to 2 pages. So, is there going to be really intense scrutiny of this bill? I don't think so. I'll try to explain the bill here so that you have a better idea of what it does and what it doesn't do. But I stress that I have no expertise when it comes to the technology side, so some of the important analysis is going to be beyond my capacity. Like the misinformation bill, this bill pushes responsibility onto certain social media platforms. In this case, the responsibility is to prevent users under the age of 16 from having an account with the platform. It requires the platforms to, quote, take reasonable steps, unquote, to prevent people who are under the age of 16 from having such accounts. Now, what platforms are we talking about here? Well, they use the term age-restricted social media platform, and that's defined in the bill as an electronic service which has the sole or a significant purpose of enabling online social interactions between two or more end users. That interaction includes posting material on the service and interacting with other end users. To be covered, material on the service must be accessible to one or more end users in Australia. And I'm guessing here that this would mean it would be accessible in Australia if you were using a VPN. The Minister may make legislative rules, like regulations for example, to include in this category other electronic services that would fall outside of the definition if the Minister is satisfied that it is, quote, reasonably necessary to do so in order to minimise harm, unquote, to under 16-year-olds. The Minister can also make a legislative rule that excludes services from that definition. According to the explanatory memorandum, the Minister proposes to make legislative instruments that exclude messaging apps, online gaming services, and services with the primary purpose of supporting the health and education of end users. One can imagine the conga line of lobbyists that will now be acting on behalf of various platforms to get nominated for an exclusion. In short, while the legislation sets a very broad definition, it's the Minister who gets to decide what's in and what's out, giving her huge power. There is, however, a degree of parliamentary supervision. These rules will be legislative instruments that are disallowable. Now that means that they have to be tabled in Parliament and either House can vote to disallow them within a certain period of sitting days. While I don't proclaim to have any expertise about how platforms and social discussion groups work, I would imagine that there would be problems here concerning the scale of the relevant endeavour. For example, if kids at school have chat groups to help with their homework, or they're groups that are directed at sport or the school musical or their hobbies like a cycling club or an art club, all of which may be good things, whether or not they'd be able to continue to exist would seem to depend on the platform used to support them. If there were Facebook groups, for example, then Facebook would have to exclude all the under-16s from having accounts because Facebook covers a huge range of content, not just the things that are educational or otherwise worthy. So being for a good purpose wouldn't really help you there. But if you used a WhatsApp group, that would seem to be okay because it's a messaging app and it's proposed to be excluded by way of a legislative instrument. What if the school, or indeed the students, set up their own website with, for example, a blog about school sporting achievements where the students could, through their school email accounts, upload photos of sporting competitions or make reports or comments about them? Teenagers, who are often very cluey about technology, would be able to do that. To continue to function in relation to under-16s, would they then have to go to the minister to seek an exemption in a legislative instrument? While this might prove an interesting lesson in both bureaucracy and politics, it really is unrealistic for small-scale activity of that kind to be required to seek such exemptions. Now, perhaps this is not the case and I have followed the breadcrumb trail of different definitions in the Online Safety Act incorrectly, but for the record, the word service is defined as including a website. An electronic service is a service that allows end users to access material using a carriage service, such as the internet. And an age-restricted electronic service platform is then defined as an electronic service that has the sole or significant purpose of enabling online social interaction and allowing end users to post material on it and interact with other end users. So at least to me, it seems to cover some potentially quite small-scale operations, not just the big platforms. Now, if I'm right about that, and I may be wrong, we do have a rather odd situation. Because if your worthy, educational, interactive site for young people is hosted on a large platform like Facebook, then under-16s will be excluded. If it's on a messaging app, then anything goes, whether it's worthy or harmful. If it's on your own site, you're not going to be significant enough to be able to get an exclusion, most likely. So it's only if, say, medium-sized platforms are established to do the worthy, educational and other content exclusively that exemptions are likely to be applied. What obligations would the bill, if passed, place on the providers of these age-restricted social media platforms? Proposed 63D says this: a provider of an age-restricted social media platform must take reasonable steps to prevent age-restricted users, that's people under the age of 16, having accounts with the age-restricted social media platform. And if you don't, there's a civil penalty of 30,000 penalty units, okay, which is huge. Now, going back to my earlier concern about small-scale websites, maybe there isn't a problem if no one actually has accounts to them, because this is directed at accounts. However, account is defined in the legislation to include a free account and, quote, anything that may reasonably be regarded as the equivalent of an account, unquote. So if the ability to comment is restricted to a particular group of people, for example, through school email addresses, might be restricted to your school year or something or other, then maybe that would be an account. Who knows? I don't. It's important to note here, however, that the only obligation in this bill is placed upon the provider of the platform. The obligation is to take reasonable steps to prevent under-16s from having accounts with the platform. The penalties for failing to do so are high. There is no prohibition, however, on under-16s from actually accessing online material through social media, nor is there any prohibition on parents or elder siblings or others facilitating that kind of access. Only the platforms are liable. One problem is that their liability is tied to a requirement to do something when no one can say precisely what that is. The bill does not specify how you prevent under-16s from having accounts with a social media platform or what steps will be reasonable steps to take. It comes down to you have to do something, but we don't know what it is, but we'll fine you if you don't do it. Now, I think that's rather problematic given the very large fines that are involved. One consequence might be that everyone with an account on a social media platform might have to take steps to provide evidence to verify their identity and age. Now, I know that this fuels a lot of conspiracy theories on the internet. Personally, I have no problem with people having to identify themselves if they want to make comments on social media. Many of the most abusive and despicable comments would not be made if people knew that their grandmother or their boss could see what they are saying about people and how badly they treat other people. Commentary on social media is a coward's castle where people revel in their anonymity and saying things about people that they would never say to their face. So requiring people to be responsible and accountable for their interactions would, in my view, be quite a good way of civilising at least some aspects of social media. Nonetheless, I do also sympathise with the view that too many companies require our identification data these days and treat it badly, either failing to protect it so it's hacked and sold on to scammers and fraudsters, or using it themselves for their own commercial exploitation, spamming you with unwanted emails and advertisements. The bill tries to address that by saying that if personal information is collected for the purpose of taking the reasonable steps required by the bill, then the platform must destroy that information after it's used for the verification purpose, and it cannot be otherwise used without the consent of the person concerned. Now, that's all well and good, but in reality, we all know how this goes. Personally, I always tick, or when they're sneaky and they've already ticked it, untick the box and take all the relevant steps, even when they hide them well away behind layers of web pages, to refuse the use of my details for the purposes of advertising and marketing. But I still get loads of it. They just send it to you regardless of what you've ticked on their page. I even complained a few times and they said, "Oh, you must have accidentally ticked it." Complete rubbish. There's no effective policing of these requirements, and that's the problem. So to me at least, these words are hollow unless someone actually checks that the data is destroyed and not misused. Why do we even need to include the option of this data being able to be used for other purposes with the person's consent? If people want advertising and marketing material, well, let them sign up for it. But there's no reason why these reasonable steps in this bill should facilitate that kind of information going to and being used by these platforms. Now, after all that whinging, where's the constitutional aspect in all of this? The Commonwealth has heads of legislative power to make laws with respect to foreign and trading corporations in section 5120 of the Constitution, which would cover most of the platforms, as well as laws with respect to postal, telegraphic, telephonic and other like services in section 51.5. Regulating the usage of the internet would most likely be regarded as falling either directly within section 51.5 or under the incidental power with relation to that section. So that's not really the problem. The constitutional issue is instead the implied freedom of political communication, which comes up quite often on this channel. Would such a law burden freedom of political communication. To the extent that it excludes under-16s from participating in communication on social media forums about political matters, then yes, it would burden the implied freedom. Even though under-16s can't vote, the High Court in Unions New South Wales and New South Wales No. 1 found that the implied freedom is not confined in its relevance to voters. In that case, non-voters, such as unions, corporations, and non-citizens, were still regarded as falling within the scope of the implied freedom, as the system of government and the laws of this country still affect them, just as they affect young people who can't yet vote. The next step then is to identify whether there's a legitimate purpose for the law. Protecting young people from exposure to harm on social media would most likely be regarded as a legitimate purpose. The question is then whether the law is reasonably appropriate and adapted to advance that legitimate purpose in a manner compatible with the constitutional system of responsible and representative government. This is where it becomes more challenging because there are some difficulties, at least I find it difficult, in connecting the proposed law with its purpose. I found it quite hard to discern what the specific harm was that this bill was directed to. At one point in the explanatory memorandum, it was suggested that the harm involved receiving constant notifications and distractions from social media, affecting a young person's sleep patterns and leading to social media addiction to the exclusion of other activities and relationships. But if that's the harm you're concerned about, why exclude online gaming services? Because computer games are far more harmful in terms of addiction, sleep disruption, and distraction. If the harm that you're concerned about is bullying from peers through receiving nasty and hateful messages through social media, which again is a very real harm, then why would you exclude messaging apps, which are the means of actually conveying those messages to young people? If the harm you're concerned about is being shown content that encourages unhealthy or dangerous behaviour such as eating disorders or body image problems or train surfing or suicide, again, real problems, then people can still see all those things on platforms without having an account, so the bill doesn't deal with that. Now, there may be very good reasons for making those exclusions and for the holes in the legislation, but they will still make it more difficult to justify the validity of the law if it's passed and challenged. Essentially, this law involves an attempt to do something, even though we all know that it's unlikely to achieve very much because there are so many ways around it. So is that good enough to justify the burden involved in the law? Maybe, if the burden is classed as low, but we will probably have to see how the law plays out in practice. Finally, I should point out that I have, at least theoretically, a conflict of interest here because, obviously, you're watching this, I have a YouTube channel. As far as I understand it, if the bill becomes law, young people could still watch my videos, but they wouldn't have an account which allows them to do things like subscribe or comment. Now, in a way, I think that's a pity. I'd love to educate young people better about constitutional matters because I think it's really important. And it would be good to be able to answer their questions if they have them. But when I actually checked my audience demographics, I discovered I had 0% in the category for people under the age of 18. Admittedly, that's only for subscribers. However, we don't have demographic information for anyone who just watches YouTube without an account. So hopefully younger people are still watching the Constitutional Clarion, perhaps in school to educate themselves on constitutional issues. I do hope so. Thank you once again for watching the Constitutional Clarion, and please do encourage any younger folk that you know to watch it too, even if they can't in the future subscribe to it until over the age of 16. Perhaps it could be a form of guerrilla protest if the bill does get passed. Anyway, as always, I look forward to seeing you again next time. Goodbye.